You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today I'm talking about cohabitation with someone who is very, very well known for his work in this space, Graeme Fraser. Graeme is very recently the recipient of the Members' Choice Award at the Resolution Awards, which it was quite an accolade, Graeme. Congratulations.
Thank you very much, David, and thank you for your kind introduction. Just to explain to people, I have been a solicitor for, I think it's getting on for 27 years now, and I'm well known for my work in terms of cohabitation law reform. I chair Resolution's Cohabitation Committee. I do a lot of work with Resolution nationally as well, and the Members' Choice Award was an award that recognises individuals who support, mobilise and inspire fellow members. So I was thrilled to win that back in September.
Topic of conversation today is cohabitation and the reform of the existing legislation around it, or lack of legislation, we might describe it as. One of my favourite anecdotes to share around this is if you are renewing your car insurance at any time in the near future and you go on to one of those comparison sites, in the drop-down menu where you state your marital status, it actually says common law spouse. How on earth can we ever dispel this myth whilst giant organisations like that are continuing to perpetuate it? Before I sort of get on my high horse too much, Graeme, tell me a little bit about your campaign around changing legislation or making legislation around cohabitation. What are the key issues in the first instance?
Well, Resolution itself as an organisation has been campaigning, I believe, since its inception. The committee was set up sometime after that, and I've been on that committee for many years. Now, in terms of what we're campaigning to do, we are campaigning to actually bring in a pure family law remedy for cohabitants, so couples who live together without being married or civil partnered. That doesn't exist at the moment. What we have is a combination of different statutes from many different areas of law which are quite disparate, don't particularly work together, and are very difficult to use in practice, because what you end up with is potentially having lots of different lawsuits, which is incredibly expensive, incredibly difficult to manage, and also appears in the sort of civil litigation world as opposed to the family litigation world. But principally, the issues that family lawyers are usually most concerned about are property rights, financial provision for children, and that's often aligned with arrangements for children. And there is a huge difference to the legal position if you're married as compared to if you're unmarried, and many people are simply unaware of that, and they often believe that they have acquired rights as a result of living together for a number of years. And this is what you alluded to in your introduction, that people believe that they are common law husband and wife. There was research carried out by the University of Exeter a number of years ago showing that despite various campaigns, awareness campaigns, some of them actually part government funded, there hasn't really been a significant drop off amongst the general population's belief in this. And actually the people who are most affected by this are the people who have most belief in the common law marriage myth, because it's couples between the age groups where they're more likely to have a breakup of relationship who are most effective. And that's why we've been really concerned about it. And in particular, it seems to affect vulnerable groups. So in particular, women are most adversely affected, but there's also been studies to show that it's impacting on ethnic minorities as well. So to some extent, this has become and is evolving into an equalities issue too.
Talk me through some of the really specific issues. Then you talk about property as an example. I mean, two people living together, the relationship breaks down. There is provision for this though, because you can hold the property as tenants in common or as a joint tenancy.
There is, and it's certainly true to say that if you enter into a property transaction and you're very specific as to what your intentions are at the time that you purchase a property together, then that's what's going to be put in place if the relationship breaks down or on death. The difficulty with that is that relationships are very mixed and varied, and they can go on for a long time, and what you intended to do right at the beginning of the relationship might not reflect what happened during the relationship and at the end of the relationship. And it is actually very upsetting for me to see in practice, and I'll give you an example of this, that you might send a barrister, say, a bundle of 450 pages explaining what happened during the relationship and lots of contributions that were made and sacrifices and what people consider are actually promises but turn out not to have the strength of evidence to show their promises. And it all seems to relate to what might have been discussed 25 years ago, maybe during the whole process of buying a property, where people are actually more concerned about other things, such as are they actually going to get the purchase through? And they don't spend a lot of time really thinking about how they intend to own the property. So yes, it does get covered off. There's often a report on title about it, but people are often very vague about their intentions. And in addition to that, we also have the problem that people who've been in relationships for a very long time, the paperwork that was produced by the land registry is not always clear. And we know for a fact that it's probably around 15% of couples who are actually entering into specific declarations of trust and cohabitation agreements. These are tools that we have repeatedly encouraged, but the fact is they're not seen as an essential purchase item, because people go to lawyers when they're distressed. And the problem with this law is they go to lawyers when it's too late. So they don't go to lawyers when they're formulating their intentions. They don't take advice because they believe that nothing will ever go wrong. And it's also acutely unromantic to be doing that when you're buying a home. Couples just don't think in those ways. They get into a relationship, they buy a home together, they might have children together first, because we know that nearly half, or maybe more than half actually, of all births nowadays are to unmarried mothers. And then marriage comes a long way down the track. So what we're really talking about here is that the law as it stands does not reflect how people are choosing to live their lives. And it's affecting such a huge part of the population that we can no longer leave it to areas of the law that aren't equipped to deal with it. Property law isn't equipped to deal with it. Talata, which is the main piece of legislation, applies to all areas of living. So it could be commercial transactions, but when we're talking about family life situations, we do need law that actually properly deals with that, and it acknowledges and respects the real contributions made by both members of the family, and that includes bringing up children, looking after the home. These are concepts that have been very well developed in English law for around nearly 25 years now, because in the year 2000 we had the seminal case of White and White, from which we have the principle of equality effectively, and that just hasn't translated for couples who don't live together, and we say that's wrong.
Why hasn't this become a judicial issue? Why haven't we had more precedent around this? You talk about White and White, I mean, it's 25 years ago. Why hasn't there been more precedent since?
The simple answer to that is a case called Burns and Burns, which was actually decided 40 years ago. And in the case of Burns and Burns, the Court of Appeal, as then constituted, made clear that if you wanted to change the situation of somebody who was unmarried, but married in all other respects except in name, in other words, except for the marriage certificate, then only legislation would be able to achieve this. So the answer to that point is that you can only resolve this through legislation. Many cases don't get off the ground because these contributions will not be considered. If I run a Talata case, you are running it through a civil procedure, which is front-loaded, expensive, uncertain, risky, very heavy cost consequences if you lose, and simply you're not going to get the test cases that are going to change the law. And even if you did, there would be nothing that the court would be able to do about it. There was a case called Gowan Grant back in 2012, and Baroness Hale at that point, when considering a Scottish case, said it was time that English courts adopted the law. So there have been recommendations from the Supreme Court in the past to change the law, and that's since the Burns and Burns case. But effectively, we're 40 years on, and the law is actually in a worse state because there weren't so many people cohabiting 40 years ago, but we still haven't repealed it.
I seem to recall a stat I read recently that 1 in 3 first-time buyers are cohabitees. Drawing on the two responses that you've given there, what are the lessons that we can learn from other jurisdictions? I mean, I hear that France, for example, a marriage is actually quite a transactional activity. You talked about Scotland and sort of the law there. What can we learn from other jurisdictions that we can implement here?
I think what we can learn is that in many other countries, not all countries, but in many other countries where the legislation has been introduced, it's been relatively uncontroversial. It has worked well. And also, something that I think policymakers and governments are really terrified of, it doesn't necessarily produce a huge amount of litigation. What it does provide is clarity. It also doesn't downgrade marriage. And I want to be really clear here that nobody who supports cohabitation reform says that marriage should be devalued. No one has ever said that. I'm as much in support of married life and actually, funnily enough, committed and stable relationships as anyone else. If somebody comes in and says they want to save their marriage, I'm professionally bound to help them to do that. So I'm not against that. But the fact is that we have seen in other countries the development of various different methods of dealing with this. One is called de facto relationships, which applies in many of the Commonwealth jurisdictions, particularly Australia and New Zealand, whereby couples are treated after a certain period of time as if they were married. And then we have other solutions, such as Scotland in particular, whereby the law follows what we call a sort of opt-out position, whereby once you've been cohabiting for a certain period of time or you've got children, then you would actually have to create an agreement to opt out of various protections that would be given, which would enable you to demonstrate in certain circumstances either that there was a sort of financial advantage or financial disadvantage as a result of living together. And that's similar to the track really that the Law Commission has gone down. Now, in Scotland, the law isn't perfect and they're actually looking to reform that law. But my comment about Scotland is at least they've got law to reform, because we haven't got any law in England and Wales as it stands. Now, I think comparative law is extremely useful to look at, and I want to commend in particular the work of Dr. Andy Hayward and Professor Jens Scherp, who've between them compiled a relatively comprehensive guide to this. And I think there's probably a publication coming out very soon, which would assist policymakers to understand comparative law. There's plenty of information about it, but I think the key thing here for England and Wales is what we want to see is that a law that is going to be useful and fit for purpose. I don't want us to feel that we went for 40 years to actually change the law and then end up with a law that doesn't work. So if it's very clear, and I think it's often very clear, that in England we do not see that it is right at this time to introduce legislation equating cohabitation with marriage, then that is not the track to go down. What I think we need to be looking at is law that provides essential protection for couples and in particular women and children who are left vulnerable by a relationship breakdown, and also tap into equality issues as well, which all new legislation should be doing in any event.
Your passion for this topic comes across in absolute spades. But let me ask you whether there are unintended consequences of some of what you've described there, that some sort of opt-out or some sort of assumed cohabitation might create.
Yeah, I think people have got concerns, and particularly where cohabitation law has been introduced. I think one of the concerns is that if you say that you have to cohabit for a specific period of time, then there may be people who deliberately engineer devices to bring a relationship to an end before you get to the 2-year mark. That's one issue that's cropped up. I think we have to look at that possibly through the lens of abuse. and I use a small a for that, because if there are circumstances where you need to look and disapply the qualifying period to ensure that people are protected, then you need to do so. Also, one of the issues that people say is going to arise is whether couples were actually cohabiting or not cohabiting, because we know that, I think in Australia in particular, there have been some arguments about whether a couple are cohabiting. All I can tell you from the many years of practice that I've been doing, cohabitation is relevant in terms of financial remedies on divorce. But I would say it is quite seldom to find a case where you couldn't establish when a couple were living together. And actually, in practice, I don't find it's really much of an issue. I think cohabitation when you see it, and I think a couple readily acknowledge it. And if it's put to the test, I think a judge can fairly easily work out, once that relationship had gone into what I call a stable and committed cohabitation relationship. So I don't think the working out of it will be as difficult as people think. And in any event, I think that new law is going to give a huge opportunity for people to move along in a much more amicable and constructive way, using processes out of court that simply don't work as well today. And therefore, I see legislation as a hugely positive opportunity to improve people's lives and their children's lives. And therefore, I'm not seeing the downside that some people are worried about. But I understand people are going to have concerns. And if legislation is introduced, I would like to think we would work alongside the people who have their concerns and try and meet them as best we can.
Having very recently done a podcast about no-fault divorce, the devaluation of marriage is quite relevant. It was interesting that the concerns about devaluing marriage that were around in the 90s were less prevalent at the point at which no-fault divorce was implemented in 2022. But there still isn't a huge amount of appetite to move this forward. The recent Conservative Party conference was pretty silent on the issue, albeit that the Labour Party conference did make some positive noises about changing the law.
Well, I'm going to venture to disagree with you on that. I think that there have been some significant movements in recent years. And I think, first of all, the work that was done by the Women and Equalities Committee, which was back in 2021, which was a parliamentary inquiry in which I gave evidence on behalf of resolution. And there was also some very important evidence given by all groups, was written up in a report. And I think that report is very solid, has a solid set of recommendations for reform, and I find them to be compelling. And I say that because I think resolution's evidence is compelling. So my point about that is that the argument is well founded, well made out, and it's now a matter of parliamentary record. This follows on from a Law Commission report back in 2007, which I would say intellectually remains pretty sound. Now, on top of that, we have seen recently a speech delivered at the Labour Party conference by Emily Thornberry, which made cohabitation reform quite central to her policies to try and promote equalities for women. Now, I may be somewhat apart in terms of what Emily Thornberry is saying, and we're waiting for the detail of what she means. But if we are going to see cohabitation reform ending up in the Labour Party manifesto, we have the prospect of this being in both the Labour Party manifesto and also the Liberal Democrat manifesto, which it was in before the previous elections. And then you've got two of the three main political parties actually advocating cohabitation reform. The issue of the government deciding not to deal with the reform, yes, that is deeply disappointing. But the important point is that intellectually, I believe the argument has been won. I can't predict the outcome of the next election. I don't say with confidence because I'm not a betting man. But I think the fact that one of the main political parties sees it as being relevant, it could mean that it does end up being part of government legislation, whatever the colour of the government. We only have to go back, I'm talking about many years ago, but with my historical knowledge, the Beveridge report, which introduced the NHS, was actually a Liberal proposal. It ended up with the Labour government making it. I think ultimately, though, where you're coming from is right, that what we want to see is we want to see a cross-party acceptance of the need for cohabitation reform, which then means that it becomes non-controversial and will pass through the statute books relatively easily. So we have a sort of peaceful and calm introduction of new law that people don't find hugely controversial. Nobody wants to see lines about potential catastrophe if there's new law. You know, there are people who say there will be catastrophe, but as I said earlier, this didn't happen in other countries. So I think that if it does come about, it will be as a result of consensus and as a result of the issue no longer being considered to be controversial. And I think when the climate is right, because of the good case that has been made out of it, and because of the parliamentary record and everything that's come before, and the sheer numbers of people cohabiting, I do think it, you know, even on a slow news day, it might not create that many ripples. So I really want people to see this in context.
I wholeheartedly take your point that we're updating legislation that is hopelessly out of place with the societal changes that have happened. I mean, surrogacy is another example that we've written about in today's Family Lawyer quite extensively, where the law simply hasn't kept up with changing nature of relationships, changing views of society, and it's something that we have to make a change to and reform. Can you expand, and I don't necessarily want you to explain the whole machinations of what the law might look like, but can you, in a sort of a bit of a nutshell, outline what this legislation looks like, Graeme?
It is not difficult to do so because there's lots of documents that you can refer to. So I'm saying all the research is there, the paperwork's there. So, I mean, you start off with the Law Commission's report, which advises for the sort of opt-out process. And then there have been various private members' bills in the House of Lords over the years, particularly Lord Leicester and then Lord Mark's many attempts. And then we can actually have a look at resolutions proposals, which are relatively simple to understand, and essentially after a period of qualification likely to be 2 years if you don't have children, or if you have children automatically, there would be the ability to have access to a similar menu of remedies that apply on financial remedies, but they apply in a very different context. So you are going to have to prove some sort of what we describe as being relationship generated disadvantage in order to take advantage of that claim. So if one goes back to the Law Commission proposals, there are different examples of couples who live together and whether they're likely to be eligible. So one example where they wouldn't be eligible would be perhaps students who are living together, they're possibly in their late teens, early 20s, and then they end up living together and they happen to be in a relationship, an early relationship in their lives. We don't think those sorts of couples are likely to be eligible. However, the sorts of couples I think this is going to apply to, and I said this in my evidence, I think there are two of them really. One, which is the Burns and Burns scenario, where a couple have been together for many years, perhaps 20 years, and they've actually had children together, and those children are grown up. And by the end of that relationship, it would often be the mother, the woman in that relationship had to give up work, had to look after the children, wasn't able to contribute to the mortgage, what we call the acquisition of the home, and therefore otherwise wouldn't have any remedies. But in this situation, her contribution would be fully recognised. And I think that is a scenario that the law urgently needs to address, because I have had people come to see me about that, and it's an appalling situation for the family, and actually the grown-up children get involved, and actually it results sometimes, these are the cases I see, in the men getting embarrassed because they know that the law just doesn't work, so we have to work around the law. That cannot be right, because we know there must be cases where that's slipping through and people are relying on the state, and it's just wrong. And it's in those long relation cases I'm really bothered about, because as I said earlier, the land registry documents probably don't work. And the other situation is, a situation we're regularly instructed where a couple have children and they are of school age, but it's the father who is holding all the cards because he owns the property, he's been making the financial contributions, and the redress that a woman might get under the other legislation, Schedule 1 Children Act, just simply isn't going to be enough, for her to be able to live with her children. And when I say not going to be enough, I'm not talking about Schedule 1 being inadequate in terms of what it's termed and what it provides, but it's the relatively limited access that women have to Schedule 1, because those Schedule 1 cases tend to apply where there's loss of wealth. So I think we're looking at reforming those areas in particular, and doing that would just make people able to move on with their lives and live sensibly, and us be able to negotiate solutions. Because I want to emphasize that people who are against reform thinks, well, if you bring in new law, how are the courts ever going to cope? You know, they have loads and loads of claims. It's not about that. It's about having new law that actually works, that people can manage and negotiate solutions, because family lawyers spend most of their time negotiating solutions. They don't go to court about everything. It's only in the very high conflict cases, and yes, there probably will be a few cases where it happens, and so there should be, but it's about producing an overall framework of rights and responsibilities that just don't exist at the moment. And if they underpinned the law in the way that they should and they do in other countries, then we would be able to advise couples and people would be able to move on with their lives, and it would just work a lot more fairly.
There's an interconnectivity point here about making sure that when we change the law, we are taking account of all of the conversations that are happening. And very specifically, the one that comes to mind is the current Law Commission review of financial remedies. Do we need to make sure that the Law Commission are thinking around that?
I don't think so. There's two different things going on here. So you've got married couples and you've got unmarried couples, and there's a significant number of unmarried couples, which is maybe 25% of our caseload nowadays. I don't know. It's a lot more than it used to be. And then you've got what happens on financial remedies on divorce. Now, financial remedies on divorce is by no means perfect, and we can improve the legislation on that. We can improve the wording of the statute, and perhaps we can improve the guidance. But that of itself doesn't need to happen before you do anything about cohabitation, because if you do nothing about cohabitation, what you're doing is you're adding to the injustice of the years that tick on by, while the numbers of people who are already affected by this continue to have no provision, and actually will increase in the meantime. So I'm saying I find intellectually it's wrong to align one with the other. Now, it is true to say, when I say that in Australia, when they changed the law on financial remedies on divorce, they decided at that point to actually reform cohabitation law at the same time and put it in the same statute. Now, I don't know what's going to happen in the future, what might happen with a future government, but I do think that we're keeping the two things separate, and I think we need to be careful in our minds not to put the two things together, because we are missing a huge part of the population who need the protection and the equalities and the rights now. So I do feel that it is not a case of just waiting many years to go through a Law Commission report, but doing the two things at the same time. It's too big a population. The demographic is too big to be ignoring one while dealing with the other. So I can't agree with that, I'm afraid. And in addition to that, we've got the Law Commission recommendations on weddings, which still haven't been considered. I don't know where the government are with that, but there were 57 recommendations. And that's another part of our campaign, because we need to be clear that people who think they're married but are not married are getting rights. And the best way for them to get rights, if they're not married, is to have cohabitation law reform.
So just to finish off, because we're fast moving out of time, Graeme, you've talked about the fact that Resolution are very, very heavily involved in this. If people want to get involved, or they want to have their say on cohabitation reform, how are they best doing that?
Cohabitation is seen by Resolution as the next priority for reform. There are lots of areas of family law that need reform, and I've never said, one is necessarily more important than the other. There's difference of views. Family law is a big area of the law, but I anticipate that we may be able to tap into more examples of what is happening across the country, and also more research and what I call good quality survey information. So I see this very much as an ongoing campaign. All practitioners and anybody involved in family law can get involved, and anyone who's a member of Resolution, by contributing towards that campaign in terms of coverage and promoting what I would call reform, and also awareness of the lack of rights that we alluded to at the beginning of the podcast, that people believe in the concept of common law marriage and wife. We know that this campaign over the years has been successful in terms of coverage in Parliament. When civil partnerships were being expanded to mixed couples as opposed to same-sex couples, the common law marriage myth was very much referred to in Parliament. So it's about creating influence, and it's really about credibility, because I think the more members who get involved, the more there becomes a momentum for change, because the government does listen to resolution when it comes to reform and does take seriously what family law is saying, because we are coming with a non-confrontational approach. We are trying to resolve conflicts, and what we are saying very loud and clear is, if you change this injustice, we will be able to help more people and they will have better and fairer outcomes. And what we've seen from the successful no fault divorce campaign is that largely when that finally came about, it's been relatively non-controversial. I've only seen one case, or I can only recollect one case in respect of no fault divorce, and that was in relation to speeding up the timeline, I think, which is something that could have happened under the old rules. But these were new rules that have worked very well and actually led on the ground to more people being able to resolve these issues themselves, which I'm sure the government would like to see. And also, when we actually provide our advice, we provide our advice, giving people solutions that they need on their actual problems, without having the problem of the bad law in the first place. So those are the sorts of ways I think people can be motivated and assist in the momentum of creating better awareness and motivating the need for change and reform.
I often think about the impact that Kate Garraway's issues with her husband and the fact that he didn't have an LPA relates to this particular issue. And I've said to a few people that perhaps we need some sort of influencer to have a relationship breakdown of some description and ultimately suffer loss for this to become a bit more of a national issue. Not that we would wish that on anybody, but it would raise the profile of it to a slightly different audience as well. Graeme, we've run out of time. It's been a fascinating discussion on the topic of cohabitation, and I can't thank you enough for joining the podcast. So thank you very much indeed.
Thank you, David, and it's been a pleasure to be your guest today. Thank you very much.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on today'sfamilylawyer.co.uk. My thanks to Graeme. Thank you for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at today'sfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.